Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, we're shaking it up a bit with some contract law, and also I guess it's employment law as well. We've got Machtinger and HOJ Industries, which I believe now is primarily taught as a contract law case, but it does come up often in discussions of employment law as well. So, Zach, do you remember learning about this one?
I don't remember learning about this. I have a very bad memory when it comes to contract law, and maybe it's because I've kind of blocked contract law out of my collective history because it wasn't really one of my best classes in law school. I remember a lot of them when I see them in reading now because I do have to read about contract law for articling research. There's a bunch with boats. Those are the ones that I remember the most for some reason. It's all the ones involving steamships and boats and international shipping, normally out of Hong Kong. For some reason, the Hong Kong High Court or whatever it was called was very busy. Those are the ones that I remember. And then one or two about it's a car salesman one or a rental car one with an agreement on the back, and it was really small. Those are the ones I remember. These other ones, for whatever reason, I read them, I'm like, oh, this is such a fascinating case. I wish I would have learned it in law school. And then I look at my cans and I was like, oh, I did. I did. Just got to put my head down.
So I loved contract law, but for very biased reasons. It's just because when I grow up, I want to be Professor Claire Momet. So I'm very biased. I liked it because I just found her so wonderful. But I do hear you because my brother is currently a 1L at Queen's Law, and he was telling me the other day about a case he'd read, and it was almost like having some sort of PTSD symptoms. The second he said it, I was like, oh, no, I hated that one. It was so long and it made no sense and I hate it so much. And he's like, well, do you remember what it was about? I'm like, no, I just remember I hated it and that we had to draw a diagram to explain what was actually happening. And funnily enough, I actually think it's the one you were talking about with the Hong Kong High Court because it's Pao-On.
Yes.
Which literally was
yes, it's Pao-On.
Yeah, it was so confusing that we had to draw a flow chart like Charlie and It's Always Sunny in Philadelphia with strings in order to make sense of anything that was happening. But anyway, I digress. Back to poor Mr. Machtinger. The reason we learned this one is primarily because of implied terms. So it involves a car salesman. They were let go. It's a wrongful dismissal case talking about, severance and notice and all those good things. So technically it's an employment case, but what's happened over time, because it's pretty old, I think. It's definitely older than you. I think it's 91 or so. So it's an old one. And
okay.
Yeah, it's older than Zach. So there you go. And then it's not older than me. So now everybody knows how far apart in age we are.
Yeah, we've let the cat out of the bag.
Yeah, we've let the cat out of the bag. So yeah, it's primarily known now for about implied terms. So I know that McLaughlin has a concurring decision where she sort of goes through implied terms, intention of contracting parties, and how that sort of works. And that part of the decision, the concurring element written by Justice McLaughlin as she was then, that's what gets repeated the most. So when I did Uber and Heller this past summer, twice because of a recording failure the first time, they talk about it a lot. They bring up her specific concurring decision repeatedly just for the discussion of implied terms. So implied terms and employment. So that's sort of where we see it now mostly, but it's refreshingly short, I must say. For an SCC decision.
Those are always nice.
I know. Refreshingly short for an SCC decision. Most of them are quite long, so it was a nice, refreshing time. I like it because it's very easy to understand, especially Professor McLaughlin is Professor McLaughlin, wow. Chief Justice McLaughlin, pardon. She's the queen of accessible language, her and Justice Abella, so It's very easy to read. It's really great. It's definitely interesting, especially if you do anything related to employment or contract more broadly. Implied terms is definitely a key concept that lots of people still don't understand. So even now in practice, so it's a good thing to learn. And yeah, hope you enjoy this one. It's an oldie, but it's a goodie. Enjoy. Machtinger and HOJ Industries Limited. Heard November 5th, 1991, March 2nd, 1992, and April 30th, 1992. on appeal from the Court of Appeal for Ontario. The judgment of Justices Laforêt, Loret-Dubé, Sopinka, Gonthier, Corey, and Yakabuchi were delivered by Justice Yakabuchi. This appeal concerns the contractual rights of employees who are dismissed without cause by their employers. Specifically, where a contract of employment provides for notice periods less than the minimum prescribed by the applicable employment standards legislation, which in this case is the Employment Standards Act, RSO 1980, and absent any claims of unconscionability or oppression, is an employee entitled to reasonable notice of dismissal or to the minimum statutory notice period? The answer to this question is of considerable importance to employees. Indeed, it has been pointed out that the law governing the termination of employment significantly affects the economic and psychological welfare of employees. The law governing termination of employment is obviously of significant importance to an individual worker, for the degree of job security which he is assured depends upon the ease with which the law allows his employer to terminate his employment. Discharge has serious financial ramifications for the individual in that it puts an end to remuneration, as well as to less quantifiable economic benefits such as accrued seniority. Discharge can have ongoing financial effects as well, for the reason given for termination, if any, may affect accessibility to future jobs, as well as entitlement to government benefits such as unemployment insurance. The psychological effects of discharge are also important, because of the disruption in the individual's life caused by seeking new employment and establishing himself in a new environment. Part 1. Facts. The two appellants were employed by the respondent HOJ Industries Limited, which was a new and used car dealer. The appellant, Marek Machtinger, began working as a car salesperson for the respondent in 1978. Machtinger was continuously employed by the respondent except for a 3-month period in 1980. On June 24, 1985, Machtinger was dismissed by the respondent, which is not alleged that it had cause for dismissal. At the time Machtinger was dismissed, he was credit manager and rust-proofing sales manager for the respondent. His earnings in his last full year of employment were $85,342.36. The appellant, Gilles Lefebvre, also began working for the respondent in 1978. He was also discharged on June 24, 1985, and again, the respondent has not alleged that it had cause to dismiss him. Lefebvre was a sales manager for the respondent at the time of his dismissal. In his last full year of employment, his earnings were $74,220.79. At issue in this case are the contracts of employment entered into between the appellants and the respondent. Machtinger entered into 2 contracts with the respondent. The second contract, dated January 11, 1985, was for employment for an indefinite period. The relevant portion of the contract is the termination provision, which reads as follows. Termination. Employer may terminate employment at any time without notice for cause. Otherwise, employer may terminate employment on giving employee 0 weeks' notice or salary, which does not include bonus, in lieu of notice. Bonus, if any, will be calculated and payable only to the date of the giving of notice of termination. The contract is on a pre-printed form, with a blank space left for the notice period. The digit 0 has been handwritten in the blank space. The relevant contract between the respondent and Lefebvre was dated January 10, 1985, and was also for an indefinite period. The termination clause is in every respect identical to that in the document signed by Machtinger, except that the period of notice for termination without cause is 2 weeks. That is, the word 2 has been handwritten into the space left blank for the notice period. The appellants acknowledged at trial that, save for the effect of the provisions of the Act, the termination provisions were valid. The appellants made no allegations of unconscionability or oppressive acts on behalf of the respondent. After Lefebvre and Machtinger were dismissed, the respondent paid each of them the equivalent of 4 weeks' salary. Part 2. Judgments below. A. Supreme Court of Ontario. The 2 cases were tried before Justice Hollingworth on April 9th and 10th, 1987. On April 9, 1987, Justice Hollingworth made a preliminary ruling on the standard for determining the appropriate notice period in each case. The issue was whether the payment of 4 weeks' salary in lieu of notice to Machtinger and Lefebvre was sufficient, or whether Machtinger and Lefebvre were entitled to what would be considered reasonable notice at common law. Justice Hollingworth held that Lefebvre and Machtinger were entitled to reasonable notice of termination. Relying on 2 Ontario County Court decisions, Collins and Keppel, and Pickup and Lytton Business Equipment Limited, the learned trial judge held that the termination clauses in the 2 contracts were invalid because they did not comply with the minimum notice period of 4 weeks required by the Act. In holding that the appellants were entitled to reasonable notice, Justice Hollingworth also relied on Section 6 of the Act, which provides that the civil remedies of an employee are not affected by the Act. Justice Hollingworth delivered his judgment orally on April 10, 1987. At the outset, he rejected the argument that the period of reasonable notice should be reduced because the present appellants had signed contracts in which they agreed to very short notice periods. The respondent had argued, following Pickup Supra, that the period of notice should be reduced by 25% because Machtinger and Lefebvre had agreed to very short notice periods. Justice Hollingworth found that this case could be distinguished from Pickup because the termination clauses in this case were unconscionable. Following Bartle and Gloman Mail Limited, Justice Hollingworth held that the period of reasonable notice for Machtinger was 7 months and for Lefebvre 7.5 months. He left the quantum of damages to be agreed between the parties. B. Ontario Court of Appeal. The unanimous judgment of the Ontario Court of Appeal allowing the respondent's appeal was delivered by Chief Justice Ontario Howland. The Court of Appeal found that, although the attempt of the parties to contract for a period of notice less than the minimum required by the Act was necessarily null and void, the course of dealing between the parties and the terms of the contract provided evidence from which the intention of the parties could be inferred. However, Chief Justice Howland found that the parties had never intended that there should be a period of 7 or 7.5 months' notice. Quote, "In my opinion, a term should not be implied that a contract of employment could only be terminated on reasonable notice, where the parties have, by agreement over a period of time, expressly provided for either or no notice for 2 weeks' notice. While the express termination provisions are null and void under the Employment Standards Act, there is evidence before the court as to the prior dealings between the parties and the existence of employment contracts whose terms represented the agreement of the parties. In those circumstances, a term requiring reasonable notice should not be implied. The parties never intended that there should have been a period of 7 or 7.5 months' notice. Chief Justice Howland held that Pickup was not good law, and distinguished Collins on the grounds that in that case the circumstances had so changed over the course of the plaintiff's employment that the whole substratum of the contract disappeared. In the absence of an implied term of reasonable notice in the 2 contracts, Chief Justice Howland held that Machtinger and Lefebvre were limited to the benefits conferred by the Act. The minimum period of notice being fixed at 4 weeks by Section 4(1)(c) of the Act, Chief Justice Howland held that the respondent had complied with the Act by paying Machtinger and Lefebvre 4 weeks' pay in lieu of notice. Part 3. Statutory Provisions. Employment Standards Act, RSO 1980. 1. In this Act, employment standard means a requirement imposed upon an employer in favor of an employee by this Act or the regulations. 2. This Act applies to every contract of employment, oral or written, express or implied, where the employment is for work or services to be performed in Ontario, or where the employment is for work or services to be performed both in and out of Ontario, and the work or services out of Ontario are a continuation of the work or services in Ontario. 3. Subject to Section 4, no employer, employee, employer's organization, or employee's organization shall contract out of or waive an employment standard, and any such contracting out or waiver is null and void. 4. An employment standard shall be deemed a minimum requirement only. A right, benefit, term, or condition of employment under the contract, oral or written, express or implied, or under any other act or any schedule, order or regulation made thereunder that provides in favor of an employee a higher remuneration in money, a greater right or benefit or lesser hours of work than the requirement imposed by an employment standard, shall prevail over an employment standard. 6. No civil remedy of an employee against his employer is suspended or affected by this act. 40. No employer shall terminate the employment of an employee who has been employed for 3 months or more unless he gives 4 weeks' notice in writing to the employee if his period of employment is 5 years or more, but less than 10 years, and such notice has expired. Where the employment of an employee is terminated contrary to this section, the employer shall pay termination pay in an amount equal to the wages that the employee would have been entitled to receive at his regular rate for a regular non-overtime work week for the period of notice prescribed by subsection 1 and any wages to which he is entitled. Part 4. Issues on appeal. This appeal raises one issue, namely, if an employment contract stipulates a period of notice less than the required by the Employment Standards Act, is an employee who is dismissed without cause entitled to reasonable notice of termination or to the minimum period of notice required by the Act. Part 5. Analysis. A. Introduction. At least on their face, the two contracts at issue in this case represent attempts to contract out of the minimum notice periods required by the Act. Under these circumstances, the question posed by this appeal is deceptively simple. Of what significance is an attempt to contract out of the minimum notice requirements of the Act? Chief Justice Howland held that, although the contractual terms were in breach of the Act, they were nonetheless relevant to determining the intention of the parties as to what the notice period should be. Specifically, Chief Justice Howland held that the terms of the contracts entered into by the parties were such as to make it unnecessary and improper for the court to imply a term of reasonable notice. Instead, Chief Justice Howland gave effect to the intention of the parties, as evidenced by the terms of the contract they entered into, and held that the appellants were entitled only to the minimum notice period set out in the Act. With respect, I cannot agree with the reasoning of the Chief Justice of Ontario, and I have come to the conclusion that the appeal must be allowed. I divide my analysis into 3 parts. In the first part, I discuss the common law presumption that reasonable notice is required to terminate contracts of employment for an indefinite term. In the second part, I review the impact of the provisions of the Act on the 2 contracts at issue in this appeal. Finally, I turn to a consideration of the policy dimensions of the issue before us. B. Reasonable notice at common law. The history of the common law principle that a contract for employment for an indefinite period is terminable only if reasonable notice is given is a long and interesting one, going back at least to 1562 and the Statute of Artificers. The Statute of Artificers prohibited employers from dismissing their servants unless sufficient cause had been shown before 2 justices of the peace. By the middle of the 19th century, however, English courts were beginning to imply a term into contracts of employment that the contract could be terminated without cause provided that reasonable notice was given. Although it was initially necessary to prove the incorporation of a custom of termination on reasonable notice into the contract in each particular case, the English courts gradually came to accept reasonable notice as a contractual term to be implied in the absence of evidence to the contrary. In Canada, it has been established since at least 1936 that employment contracts for an indefinite period require the employer, absent express contractual language to the contrary, to give reasonable notice of an intention to terminate the contract if the dismissal is without cause. The parties devoted considerable attention and argument before us to the law governing the implication of contractual terms, and specifically to the relevance of the intention of the parties to the implication of a term of reasonable notice of termination in employment contracts. The relationship between intention and the implication of contractual terms is complex, and I am of the opinion that this appeal can and should be resolved on narrower grounds. For the purposes of this appeal, I would characterize the common law principle of termination only on reasonable notice as a presumption, rebuttable if the contract of employment clearly specifies some other period of notice, whether expressly or impliedly. This is the approach taken by Friedland, who states that the pattern of contract now generally accepted and applied by the courts in the absence of evidence to the contrary is one of employment for an indefinite period terminable by either party upon reasonable notice, but only upon reasonable notice. The same approach was adopted by the Ontario Court of Appeal in Prozac and Bell Telephone Company of Canada. Writing for the court, Appeal Justice Goodman noted that if a contract of employment makes no express or specifically implied provision for its duration or termination, there is likely to be implied at common law a presumption that the contract is for an indefinite period and terminable by a reasonable notice given by either party. Basically, this is also the approach taken by I. Christie in employment law in Canada. Quote, "What constitutes reasonable notice will vary in the circumstances of any particular case. The most frequently cited enumeration of factors relevant to the assessment of reasonable notice is from the judgment of Chief Justice of the High Court McRuer in Bartle. There can be no catalogue laid down as to what is reasonable notice in particular classes of cases. The reasonableness of notice must be decided with reference to each particular case, having regard to the character of the employment, the length of service of the servant, the age of the servant, and the availability of similar employment, having regard to the experience, training, and qualifications of the servant." Justice Hollingworth referred to the factors set out in Bartle in determining what would constitute reasonable notice for the two appellants. His determination in this respect was not challenged in this appeal. C. The Employment Standards Act. It was acknowledged by the appellants and the respondent that, but for the possible effects of the Act, no issue as to the validity of the employment contracts would have arisen. The presumption at common law that a contract of employment for an indefinite term is terminable only on reasonable notice would have been rebutted by the clear language of the contract specifying shorter notice periods. But what is the effect of the Act? The Act provides for mandatory minimum notice periods. The provision relevant to the appellants is set out in Section 41C of the Act, which provides that an employer must give any employee who has been employed for 5 years or more but less than 10 years 4 weeks' notice of termination. Section 47A provides that, if the required notice is not given, the employer shall pay the employee an amount equivalent to his or her regular wages for the period of notice. It is also clear from Sections 4 and 6 of the Act that the minimum notice periods set out in the Act do not operate to displace the presumption at common law of reasonable notice. Section 6 of the Act states that the Act does not affect the rights of an employee to seek a civil remedy from his or her employer. Section 4.2 states that a right, benefit, term, or condition of employment under contract that provides a greater benefit to an employee than the standards set out in the Act shall prevail over the standards of the Act. I have no difficulty in concluding that the common law presumption of reasonable notice is a benefit, which, if the period of notice required by the common law is greater than that required by the Act, will, if otherwise applicable, prevail over the notice period set out in the Act. Any possible doubt on this question is dispelled by Section 4.1 of the Act, which expressly deems the employment standards set out in the Act to be minimum requirements only. What is at issue in this appeal is the effect, if any, to be given to a term of an employment contract which does not comply with the minimum notice requirements of the Act. Is such a term capable of displacing the common law presumption of reasonable notice? The effect of Sections 3 and 4 of the Act is to make any attempt to contract out of the minimum employment standard of the Act by providing for lesser benefit than those minimum employment standards null and void. The two contracts at issue on this appeal do attempt to contract out of the minimum notice period set out in Section 41C of the Act by specifying notice periods shorter than the statutory minimum. Accordingly, the two contracts are not in compliance with the mandatory language of Section 3 of the Act, and those portions of the two contracts specifying the notice periods are null and void. In argument, the respondent accepted that the attempt to contract out of the provisions of the Act was null and void, but argued that the documents should be considered as evidence that contracts were entered into which expressed clear intention of the parties with respect to notice of termination. I cannot accept this argument. In Rover International Limited and Canon Film Sales, the Court of Appeal was faced with a contract which was entirely void. Justice Kerr refused to look at the terms of the contract to limit the recovery of the appellant in quantum merit. Quote, "If the imposition of a ceiling in the present case were accepted, then the consequences would be far-reaching and undesirable in other situations which it would be impossible to distinguish in principle. It would then follow that an evaluation of the position of the parties to a void contract, or to one which becomes ineffective subsequently, could always be called for. We know that this is not the position in the case of frustrated contracts, which are governed by the Law Reform Act. It would cause many difficulties if the position were different in relation to contracts which are void ab initio. By analogy to the respondent's submission in the present case, in deciding on the equities of restitution, the court could then always be called upon to analyze or attempt to forecast the relative position of the parties under a contract, which is ex hypothesi non-existent. This is not an attractive proposition, and I can see no justification for it in principle or upon any authority." End quote. In this case, we are not faced with an entirely void contract, but a contract of which one clause is null and void by operation of statute. I would nonetheless apply the reasoning of Justice Kerr. If a term is null and void, then it is null and void for all purposes, and cannot be used as evidence of the parties' intention. If the intention of the parties is to make an unlawful contract, no lawful contractual term can be derived from their intention. In Erland and Quality Communication Products Limited, Justice Wilson was faced with a contract of employment which was void by reason of the statute of frauds. Relying on James and Thomas H. Kent and Company, Justice Wilson held that in the absence of a valid contract, he had no choice but to imply a term that the employee was entitled to reasonable notice. Moreover, because the Act declares the notice provisions of the contracts in dispute to be null and void, it seems to me that the proper question to ask in determining the parties' intention is what did the parties intend should the notice provisions be found to be null and void? There is simply no evidence with which to answer this question. In Sulman and British Columbia Research Council, Justice Lissick, on facts analogous to those in the case at bar, found that there was no evidence of the parties' intention in the face of minimum employment standards with which the employer was required to comply. Justice Lissick was considering the effect of Section 2.1 of the Employment Standards Act, Statutes of British Columbia in 1980, which is very similar in wording to Section 3 of the Act. Justice Lissick concluded as follows, quote, "I find nothing in the evidence in the present case to warrant the conclusion that the parties, had they turned their minds to the subject, would have agreed to substitute for the void contractual term the minimum period of notice required by the statute, instead of looking to the common law standard of reasonable notice." End quote. D. Policy considerations. I turn finally to the policy considerations which impact on the issue in this appeal. Although the issue may appear to be a narrow one, it is nonetheless important because employment is of central importance to our society. As Chief Justice Dixon noted in reference re Public Service Employee Relations Act, quote, "Work is one of the most fundamental aspects of a person's life, providing the individual with the means of financial support and, as importantly, a contributory role in society. A person's employment is an essential component of his or her sense of identity, self-worth, and emotional well-being." End quote. I would add that not only is work fundamental to an individual's identity, but also that the manner in which employment can be terminated is equally important. Section 10 of the Interpretation Act, RSO 1980, provides that every act shall be deemed to be remedial and directs that every act shall receive such fair, large, and liberal construction and interpretation as will best ensure the attainment of the objective of the act according to its true intent, meaning, and spirit. The objective of the act is to protect the interests of employees by requiring employers to comply with certain minimum standards, including minimum periods of notice on termination. To quote Justice Conant in Pickup, "The general intention of this legislation is the protection of employees, and to that end it institutes reasonable, fair, and uniform minimum standards. The harm which the Act seeks to remedy is that individual employees, and in particular non-unionized employees, are often in an unequal bargaining position in relation to their employers." As stated by Swinton, quote, "The terms of the employment contract rarely result from an exercise of free bargaining power in the way that the paradigm commercial exchange between two traders does. Individual employees on the whole both lack the bargaining power and the information necessary to achieve more favorable contract provisions than those offered by the employer, particularly with regard to tenure, end quote. Accordingly, an interpretation of the Act which encourages employers to comply with the minimum requirements of the Act and so extends its protections to as many employees as possible is to be favored over one that does not. In this regard, the fact that many individual employees may be unaware of their statutory and common law rights in the employment context is of fundamental importance. As B. Etherington suggests, the majority of unorganized employees would not even expect reasonable notice prior to dismissal, and many would be surprised to learn they are not employed at the employer's discretion. If the only sanction which employers potentially face for failure to comply with the minimum notice period prescribed by the Act is an order that they will minimally comply with the Act, employers will have little incentive to make contracts with their employees that comply with the Act. As Swinton and Etherington suggest, most individual employees are unaware of their legal rights, or unwilling or unable to go to the trouble and expense of having them vindicated. Employers can rely on the fact that many employees will not challenge contractual notice provisions, which are in fact contrary to employment standards legislation. Employers such as the present respondent can contract with their employees for notice periods below the statutory minimum, knowing that only those individual employees who take legal action after they are dismissed will in fact receive the protection of the minimum statutory notice provisions. In my view, an approach more consistent with the objects of the Act is that if an employment contract fails to comply with the minimum statutory notice provisions of the Act, then the presumption of reasonable notice will not have been rebutted. Employers will have an incentive to comply with the Act to avoid the potentially longer notice periods required by the common law, and in consequence, more employees are likely to receive the full benefit of the minimum notice periods. Such an approach is also more consistent with the legislative intention expressed by Section 6 of the Act, which expressly preserves the civil remedies otherwise available to an employee against his or her employer. Moreover, this approach provides protection for employees in a manner that does not disproportionately burden employers. Absent considerations of unconscionability, an employer can readily make contracts with his or her employee which referentially incorporate the minimum notice periods set out in the Act or otherwise take into account later changes to the Act or to the employee's notice entitlement under the Act. Such contractual notice provisions would be sufficient to displace the presumption that the contract is terminable without cause only on reasonable notice. This point was recognized by Justice Lissac in Sulman. Quote, an employer who wishes to guard against being called upon to give any more notice or severance pay than the legislation demands can readily draw a contractual clause which, in effect, converts the statutory floor into a ceiling. But here the employer has authored a contractual term which simply fails to comply with the law. In such circumstances, it is not evident why the employee should be placed in a worse position than if the contract had said nothing at all about notice of termination, end quote. Finally, I would note that the Act sets out what the provincial legislature deems to be fair minimum notice periods. One of the purposes of the Act is to ensure that employees who are discharged fairly. In the present case, the employer attempted to contract with its employees for notice periods which were less than what the legislature had deemed to be fair minimum notice periods. Given that the employer has attempted, whether deliberately or not, to frustrate the intention of the legislature, it would indeed be perverse to allow the employer to avail itself of legislative provisions intended to protect employees, so as to deny the employees their common law right to reasonable notice. Part 6. Conclusion and Disposition. I would conclude that both the plain meaning of Sections 3, 4, and 6 and a consideration of the objects of the Act lead to the same result. Where an employment contract fails to comply with the minimum notice periods set out in the Act, the employee can only be dismissed without cause if he or she is given reasonable notice of termination. Accordingly, the appeal should be allowed, the decision of the Ontario Court of Appeal set aside, and the judgment of Justice Hollingworth restored. The appellants shall have costs here and in the courts below. I have had the benefit of reading the reasons of my colleague Justice McLaughlin. I simply wish to add that, although I agree with her conclusion, I do not find it necessary or advisable to revisit Canadian Pacific Hotels Limited and Bank of Montreal to dispose of this appeal.
Thanks Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.